Okay, everyone, let me know if you hear me. We are having some technical difficulties. Let me know if you hear me, and if you don't, we will start over. Okay, apologize for the problem, and it's really upsetting because I like to show your comments. It's my favorite thing. And so it's up to you guys. If you don't mind me stopping the stream and starting another one, I will do so. Otherwise, I'll just carry forward without your comments today. But we do have a lot of work to do today, so maybe it's okay. I'll give you a second to chime in the chat, see what you think. What's up, everybody in the chat? Thanks for being here. Okay, so yeah, just let me know what you think. Should I start a new one or roll with this one? Let me know what you think. But good evening to everyone. Tuesday, May 21st. Tuesday, May 21st. It's good to see everybody here, and we will get to some business. While you're here, please hit the like. Please hit the like, and anyway, we'll get right into it. So today we're going to take a look. I'm sure many of you who are absolutely obsessed with this case and follow every 5 seconds will be aware that there was a motion to dismiss filed. And today we're going to be diving into that, giving some snarky commentary and some additional points. And that's our objective for today. And for those of you who are just listening, hopefully it'll help you out in that you won't have to read it yourself. I will read it for you, and that'll make things nice for you. What other points do I want to hit? Please support the channel. I want to thank Blessings Galore for her contribution and in a form of a super chat. And everyone, please support the channel in whatever way you like. If you're in the Lurker crew, that means joining the chat. We also have various funding pathways, and more importantly, or most importantly at the moment, I would like to draw your attention to my GoFundMe that I have established. I consulted with some attorneys, and I have a very good idea at this moment of what I'm going to need to get some things done that I need to get done, and I'm going to show you here. I'm going to try to put it in the chat. Here is the link. Okay, I'll put it in the chat here. I'm asking everyone who is concerned. Oh, did you put it, Amy? Well, that's nice. Gosh, how are you so quick, Amy? Tell you what, I'm going to pin that. Okay, if you go ahead and click that, it's going to bring you to my GoFundMe. We just started it, so do not fret that there's just a small dollar amount in there. That right there is the first half of the estimate that I got from the attorneys in regards to the legal actions that I would like to be taking. And some of you may know what those are. Anyhow, I'm asking now that anyone who would like to address this problem that plagues the YouTube community, understand that addressing it in this way might help to address the problem in the entire community, not just related to me. I'm trying to take the lead on this, but go ahead and check that out if you'd like. And we have, of course, our other support pathways, which are always open to you, and I always appreciate that. And like I say, more importantly, join the chat, participate with the chat. That is your way. And I apologize that I'm not able to post the links or the comments on the screen, I should say, today. Something's wrong with my StreamYard here, and it's just not wanting to cooperate with the posting of the comments onto the screen. So unfortunately, that's not working out. But yeah, that's where we are today. That's where we are. And I have some I have some interesting information coming to you very soon. Very concerning information, but uh, keep aware of the community post and the new uploads, I guess is the way I'd put it. Um, you might have noticed that in the past couple days, I did post some concerning reminders about Tina Rodell and her stories of her daughter and her daughter's friends, which we loosely refer to as the Kokomo crew. And there's a reason that we are currently focusing back on them, and I think that if you watch Silky's show the other night, you might have some idea of some of that. Um, so please, please remember that I'm not posting things lightly in that way. So yeah, go watch Silky's live if you haven't already, in which myself and Meow and Four Pits we discussed some things, including some of these connections with the Kokomo crew and Tina Rodell, and check out the community pages for some recent posts that I've done. Uh, and I would like to thank Silky for having me, by the way. And anyhow, so that's kind of the updates. It's been a few days, and that's all your updates. And I'm glad for everyone who is here. Um, there's a lot going on that you guys have no clue about, so I apologize for anything you're not understanding. Hopefully, you will in time. I mean, this has been going on for a good year. Okay, it's been a good year, and I still have people upset with me about the damn Discord. And just to show you, it's been a year, and people are still upset at me about the damn Discord because there were issues that arose, and oddly enough, it was a troll farm at the center of these issues that caused the issues, and that led to the nuking or the destruction of the Discord. And I still have people upset at me about that. So just understand when there's things you don't understand that are going on, there's reasons, and it's probably going all right back on those very same people. So yeah, that's what we're dealing with right now. We have controlled opposition, we have controlled YouTubers, we have controlled Redditors and Facebookers, and it's just a total media, or should I say, public relations campaign using social media that we're dealing with, and so it's very difficult. So please just bear with us as we navigate these waters, and understand that we're trying to make it through this. So, with that being said, cheers to you. I'd like to get into our business for today. All right. Now, listen, I know this is difficult. Okay, this is difficult. This is a lot of reading, and I apologize to bring you a show with a lot more reading. It's not my intention. I prefer discussion with the chat, but I tend to only bring these to your attention when they're especially concerning, powerful, and pertinent. And I believe in this instance, this one here is just that. It's why I titled the show The Delphi Murders Defense Blast the State's Case in New Motion to Dismiss. Because if you're not already familiar with this motion, you'll be really shocked tonight. There's been the defense continues to produce some pretty outstanding results, and it's very odd to me because I get blamed often for working for the defense or supporting a baby killer or all these other things that they like to say. Okay, the things that they like to say that to totally cast me in a certain light. And I just wonder if people ever listen to me because I think it's pretty clear. I know it's pretty clear to the complete defense, Richard Allen is innocent supporters, because most of you who feel that way are pretty well aware that that is not my position. That's not my stance. It's not my opinion. And it's something that I say, like, I have no idea how you could even believe that you could know such a thing. So I find it pretty entertaining that there are individuals who, because they don't like me, they figure out the best way to shame me and to cast me in a negative light is to say that I am trying to destroy the prosecution's case and support the innocence of Richard Allen, a child killer. And that's funny to me because it's so extreme in that I'm neither trying to destroy the prosecution's case nor support the allegations of innocence of Richard Allen. What I am trying to do is critically analyze the the things that are in front of me so that I am able to understand it myself. And because you guys are here with me and we are talking as friends, you get to understand some of my points of view. That's the sole reason for me being here. And I would say on those points, it's no fault of my own that the prosecution's case is so weak that the PCA was so badly put together and wrought with lies and misrepresentations. And it's neither my fault that Richard Allen's amazing defense team of Andy Baldwin and Brad Rozzi is doing such a phenomenal job with their cohorts in bringing up pertinent information and poking holes in a case that we already know is full of contradictions, complications, um, straight up lies, and odd behavior of everyone involved. So it's very telling to me that that when on the surface, this judge looks extremely biased, this prosecution looks extremely weak, and this defense and the points that the defense are bringing out from discovery look extremely concerning. When I am bringing up the obvious in these points, uh, it's not. It doesn't take a lot of work. I mean, it's right all on the surface. So as we look at this, as we look at this information and take a critical, fair, balanced review of this information, it's pretty damn compelling what the defense is bringing up, and it's pretty obvious that there are reasons that people say that Richard Allen is an innocent man because when you look at the way that the prosecution is piling on garbage on top of garbage and and uh, mishandling evidence, misrepresenting witness statements, outright lying, uh, acting extremely suspiciously, and all of the above, it's easy to say why people would say that Richard Allen is an innocent man because I wonder if you had a strong case, why would you have to do all of this to a man who you believe that you have evidence that can convict? And at this point in time, it is my opinion that this case will not stand against Richard Allen. It is my opinion that they're very unlikely to get a conviction of Richard Allen. And it's also my opinion that should somehow miraculously they do achieve a conviction of Richard Allen, that this whole thing will go to appeals court where it will be scrutinized intensely. And I just don't feel at this point that there's any hope whatsoever that Richard Allen will ever be convicted in a way that won't be overturned should it happen. This whole thing is just a complete shit show. I'm pretty much done with it. I mean, I think it's pretty clear at this point. I really don't have much more to add to this. I'm tired of it all. I'm tired of the case. I'm tired of the individuals surrounding the case. I'm tired of the lies and gaslighting. I don't think that this is going anywhere further than it is now. After we read this tonight, I think you will be astonished at some of the things that have gone on that are brought up in this document. And I must say that this document here, uh, for me personally, it brings Brad Holder uh, back into the spotlight as extremely suspicious. When I have been not focusing on him much lately because I felt that there's not much to him, uh, contrary to the others, um, or as opposed to the others who are mentioned in this Frank's memorandum, who all appear to be extremely closely connected and suspicious. As far as Brad Holder, I never really gave it much credit, but with these allegations in this document, and I would say they're not mere allegations, they're points of fact brought out through discovery that it's putting a negative light back onto Brad Holder. So altogether, it's looking pretty rough here. It's all together looking pretty rough. Okay. So let's take some time and go through it. Um, and you might see what I'm saying here. If you haven't already read this, you'll see what we got. Okay. Just give me a second to get the stuff together here that I need to get together. Okay. Here we go, guys. Here we go. So this says, "Come now, the accused Richard Allen," oh, by attorneys, obviously, and moves this court to dismiss the charges against the accused for destroying or losing exculpatory evidence or potentially useful evidence in violation of the standards set out in Brady v. Maryland. That's called a Brady violation, ladies and gentlemen. In support of said motion, the accused, or the attorneys for the accused, state the following. Here we go. And I will read through each one for you and try to only add where I feel it's necessary. So, one, that on February 7, 2024, the accused filed his motion to dismiss for destroying exculpatory evidence and memorandum in support of said motion. Two, in his first motion, the defense detailed how on February 17th, 2017, in the interview of third-party suspect Brad Holder, it was destroyed while in possession of law enforcement, along with multiple days of other interviews. Three, on March 18, 2024, a hearing was held on said matter. Four, at the March 18th hearing, Steve Mullen testified that other evidence was destroyed in 2017 as well, as it was purportedly unintentionally taped over. That's the claim. Remember, that is only a claim, not a fact. Furthermore, point 5, at said March 18th, 2024 hearing, the defense tendered Mullen's undated reports that purportedly explained how the evidence was destroyed. 6, the prosecution did not tender these reports to the defense until after the motion to dismiss was filed. Also, said reports were only turned over to the defense after the defense requested those items from the prosecution. 7, on April 2nd, 2024, the court issued its ruling denying the defense motion to dismiss the charges. 8, since the time of this court's denial of said motion, the defense has learned of other exculpatory evidence and/or potentially useful evidence that the prosecution has not turned over to the defense. That evidence is missing or that the state of Indiana has destroyed. So remember, we're talking about potentially useful or exculpatory evidence that is either not turned over, which means being withheld, missing, which means vaporized into the ethers, or intentionally destroyed by the state of Indiana. Just like Allen's first motion to dismiss, the missing destroyed evidence relates to third-party suspect Brad Holder. Okay, Brad Holder's missing phone extraction data. Just as an aside, remember that there is also missing phone extraction data for the entire family of the victims. Yes, that's right, ladies and gentlemen. The exact data you would need to substantiate their alleged timeline, their alleged activities on that day, and the time and place that these family members have stated they were on the dates of February 13 and February 14 in 2017. Okay, back to the document. 10. During a recent deposition of Brad Holder, the defense learned that Brad Holder is pretty sure, let's just put that in quotation marks, that he turned over his phone to law enforcement on February 17, 2017. 11. The prosecution has not turned over any data, extractions, reports, or other evidence from Brad Holder's phone. 12. Curiously enough, on the same day and at the same time that Brad Holder believes that he turned his phone over to law enforcement officers, his son, Logan Holder, who was dating the victim, Abigail Williams, has also turned over his own phone. 13. The prosecution has turned over the data extracted from Logan Holder's phone, but not any data extracted from Brad Holder's phone. 14. While the data from Logan Holder's phone was extracted, law enforcement apparently claim that they failed to extract data from Brad Holder's phone, even though both he and his son Logan turned over their phones to law enforcement at the same time. Point 15. Jerry Holman stated under oath at a recent deposition that he believed police, quote, just looked through Brad Holder's phone. But he encouraged the defense to find out for sure from the FBI, as if that is their job. 16. When asked if he would have extracted data from Brad Holder's phone if given the opportunity, Holman was non-committal, i.e., shucking and jiving. Depends on the circumstances, said Holman, but I think you'd have to ask the FBI what they did. Again, passing the buck as if it's the defense's job to go and ask the FBI for property of the ISP. Finally, after being pushed by the defense here in point 17, Holman finally conceded. Oh, that's a big one. That's a big one. After being pushed by the defense, Holman finally conceded that he would have extracted data from Holder's phone if given the opportunity. Well, sir, if you were given Logan Holder's and Brad Holder's phones, and you did extract Logan Holder's and you would have extracted Brad Holder's, why did you not extract Brad Holder's? And if you did, where is that extraction data, Mr. Holman? Point 18, the defense finds it highly, highly unlikely that law enforcement would take the time to collect both Brad Holder's phone and Logan Holder's phone, but then choose to only conduct an extraction of Logan Holder's phone, especially when Brad Holder on February 17, 2017, was a suspect. And no evidence provided to the defense suggests law enforcement considered Logan Holder a suspect. Point 19. On February 17, 2017, documents specifically sought out by the defense, i.e. Doug Carter's emails with the FBI, provided evidence that A, Brad Holder was a suspect within days of the murder, and certainly on February 17, 2017, when Holder interviewed at the Delphi police station and turned over his phone to law enforcement. B, State Police Superintendent Doug Carter was aware that Brad Holder was a suspect. C. Even top FBI agent in Indianapolis, Jay Abbott, was aware that Brad Holder was a suspect on February 17, 2017. D. Logan Holder was not mentioned as a suspect in these emails. Do we understand that? Do we understand that by February 17th, 2017, Doug Carter was very well aware, as was Jay Abbott of the FBI, that Brad Holder was a prime suspect? Brad Holder's phone and Logan Holder's phone were allegedly brought into police custody. Logan's phone was extracted. Where was Brad's phone extraction? Was it even done? If it was done, where is it now? Where is his interview? Oh, right. It was recorded over, quote, unintentionally, quote. 20. This begs the question, why would law enforcement take both Brad Holder's phone and Logan Holder's phone, but only extract data from Logan Holder's phone? They wouldn't. When he was not a suspect, but would not extract any data from Brad Holder's phone when he was a suspect, they wouldn't. Additionally, the defense possesses 101 phone extractions that law enforcement conducted on a variety of other phones, many of which seemingly have little or nothing to do with the murders, which is intentional. 22. This begs another question. Why would law enforcement take the time to extract data from 101 phones, most of which were not owned by suspects, yet would not extract data from Brad Holder's phone when they had his phone in their hands on February 17, 2017, and he was a suspect at that time? '23. The defense believes that the above information provides strong circumstantial evidence that law enforcement did extract data from Brad Holder's phone on February 17, 2017, and has not turned it over to the defense or has destroyed it. 24. Logic and common sense support this belief. You don't say. 25. If law enforcement failed to extract suspect Brad Holder's phone data while it was in their hands on February 17, 2017, then the only other explanation would be that law enforcement was completely and utterly inept. Not so. That's a talking point that the troll farm wants you to believe. They want you to think, oh, the police never dealt with murders. No, that's not what they've ever done. The police, they deal with drug busts and they deal with robberies, but it's such a small town. They just don't know what they're doing when it comes to murders. Even though they had the FBI right there and the state police. Rhetorical question. How many murders a year do the Indiana State Police deal with? Surely homicides occur in Indiana. Surely the Indiana State Police often deal with homicides. Surely the FBI in Indiana have been assigned homicides prior to February 14th, 2017. All evidence of Brad Holder's second interview with law enforcement is missing. Wow, mind blown. Well, mind blown. 26. Additionally, Brad Holder testified in his deposition that in addition to law enforcement's February 17, 2017 interview, which was purportedly accidentally taped over, Important words there. Purportedly accidentally taped over. That law enforcement conducted a second interview of Brad Holder sometime later, probably within a year or two of his first interview. 27. Holder further testified at his deposition that A. Law enforcement conducted the second interview at the Logansport police station. B. The interview took about an hour and a half. C. The interview was likely videotaped in an interview room. D. The interview involved much questioning about Patrick Westfall. So it appears that law enforcement was concerned about Patrick Westfall and was picking Brad Holder's brain for information on Patrick Westfall. Now, why would that be if they were not persons of interest? 28. After the deposition, the defense alerted the prosecutor's office that the defense had A. No phone dump data extraction evidence from Brad Holder's phone. B. No evidence whatsoever in the form of audio reports, reports, notes, or any other type of evidence of law enforcement's second interview of Brad Holder at the Logansport police station. 29. On May 13, 2024, the prosecution advised the defense by email that they cannot locate an interview of Brad Holder at the Logansport PD and have no record of Brad Holder's phone being downloaded. This is all true. This is not make-believe. This is not make-believe here. Apparently, Brad Holder can remember being interviewed and the contents of that interview at the Logansport PD, but prosecution has no clue, cannot locate anything. It's a whodunit. 30. At a recent deposition, when Unified Command's Jerry Holman was asked about how the defense could obtain any information about this second interview, Holman said, "I ain't got no idea." But he encouraged the defense to reach out to the Logansport PD to find out. Again, not their job. 31. The defense is not required to locate exculpatory evidence or potentially useful evidence of third-party suspects. That is a requirement of law enforcement. 32. Also, at said May 2nd, 2024 deposition, Brad Holder told a third different story concerning how many times he met victim Abigail Williams. 2 times. And that one of Brad Holder's meetings with Abigail Williams took place at Patrick Westfall's house. Does this not blow this story wide fucking open? Let's take that in reverse. One of Brad Holder's meetings with Abby Williams took place where? At Patrick Westfall's house. What's an obvious sign of deception that law enforcement looks for? that detectives are trained to look for. Inconsistencies. Brad Holder, how many times did you meet Abigail Williams? Never. Maybe once. Okay, twice. 3 times. Why is your story changing? Surely you would remember meeting the daughter of your, I'm sorry, the girlfriend of your son, the girlfriend of your teenage son who had just been murdered. Surely you would remember having had met her or not. Surely that would never change, Brad Holder. On top of that, you now know, you now state that you met her at Patrick Westfall's house, the same Patrick Westfall that you warned your wife, Amber Holder, about being a very dangerous individual? 33. When Jerry Holman was confronted with Brad Holder's ever-changing stories concerning how many times Brad Holder met Abby Williams, Holman stated, "Perfectly reasonable, in my opinion, that he remembered somebody insignificant. If you've only met them twice, you may not remember that. So I don't exactly see what you're asking me." That's pretty insulting and pretty shitty, Jerry Holman. Perfectly reasonable, in your opinion, that Brad Holder remembered somebody insignificant, that you've only met them twice, you may not remember that, so that I don't see what exactly you're asking me? Jerry Holman, I believe that Abigail Williams was significant. And I believe that even to Brad Holder, she would have been significant, being that this girl was dating his son and was brutally murdered. 34. When Holman was asked if it were likely that Brad Holder would not remember meeting Abby when Holder was asked 3 days after the murders at his February 17, 2017 interview, but then 7 years later he would remember meeting Abby twice, Holman responded, possibly, yeah. Possibly, yeah. What's with the attitude, Jerry Holman? 35. Holman showed no curiosity nor interest whatsoever about why Holder's stories have changed. This attitude supports an argument, which defense will later make in this motion, that law enforcement have acted intentionally or in bad faith to conceal evidence to such a degree that they cannot even admit obvious factual inconsistencies that point the finger at third-party suspects. In other words, who asses are you covering? 36. Patrick Westfall was interviewed on August 17th, 2024. And law enforcement extracted data from Westfall's phone. Oh, ladies and gentlemen, it gets better. Wait for this one. Wait for this one. In other words, I'm sorry, 37. Let me calm down. This document, as I said, blasts the state's case apart. It upsets me. 37. The phone extraction data shows that Westfall's phone had no data prior to August 11th, 2023, which was the same fucking day that law enforcement contacted him and asked him to come in to be interviewed. Can we say red flags? "38. In other words, it appears that Patrick Westfall either erased all of the phone data on his phone or purchased a new phone after the police contacted him on August 11, 2023. The only data found on Westfall's phone was between August 11th, 2023, on or about when the police contacted him, and August 17th, 2023, when he was interviewed. No text, videos, photographs, email messages, or any other fucking data existed on Westfall's phone before the day police contacted him on August 11th, 2023. So you mean to tell me the police call, say, Robin, we need to talk to you. Would you please come in a few days? Oh, sure, sure. Uh, Let me just delete my entire phone, wipe it fucking clean, or let me just go buy a whole brand new phone that's totally wiped clean, and yeah, I'll be in a few days. We'll see you then. "39. When Jerry Holman was confronted with the fact that Patrick Holder likely attempted to hide his phone data from the state police, Holman claimed that he found nothing unusual, stating, 'People erase things all the time.'" Really? Really, Jerry? Nothing unusual about the fact that the same day you asked him to come in for an interview, he deleted his phone or bought a new one? Nothing unusual. People delete things all the time. Later, Holman stated that he found nothing suspicious about Patrick Westfall deleting or concealing his phone data before his August 17th interview. They've got the dates all fucked up in this document. I really got to admonish the defense here. What's up with all these dates? Come on, guys. These dates are all fucked. August 17th, 2024, August 17th, 2017, August 17th, 2023. Can we pick the year? Come on, defense. Can we get the year together? Point 40. Again, Holman's attitude toward third-party suspect Patrick Westfall supports the defense's position that law enforcement has intentionally destroyed evidence or acted in bad faith, or have intentionally not provided missing evidence, such as Brad Holder's second interview, as well as the other items identified in this motion. Point 41. At his August 30th, 2023 interview, State Trooper David Vito did not even ask Brad Holder if he would allow the state police to extract data from his phone, even though it's clear that Holder had brought his phone with him to the interview. Because Vito don't give a shit either. 42. Therefore, it is not known whether Holder simply erased data from his phone, like it appears Westfall hid or erased data from his phone. 43. It certainly is curious as to why Vito did not request Holder's phone data when Holder brought his phone to the August 30th, 2023 interview. 44. It is also curious as to why Vito failed to ask Brad Holder one single question about Elvis Fields, because no shits are given. 45 is also curious as to why Vito failed to ask Brad Holder one single question as to the incriminating statements that Amber Holder attributed to Brad Holder that are detailed in the Franks 1. Yes, you remember, I just brought that up earlier. Vito's failure to ask such important questions to Brad Holder during the August 30th, 2023 interview supports the defense contention that law enforcement is acting in bad faith. Can we just say it? Can we talk real talk here? That's the nice way of saying corrupt. This is called the defense trying to use nice words. Please give me a moment. Okay, so mimicked crime scene image found on Brad Holder's social media is lost. 47, in addition to Holder's 2017 missing phone extraction and missing evidence of Holder's second interview at the Logansport police station, as well as Holder's taped over first interview from February 17, 2017, another key piece of evidence is also missing: the mimicked crime scene photo that was on Brad Holder's social media pages. 48, Trooper Purdy viewed this mimicked crime scene image on Brad Holder's social media page sometime in the spring of 2017. This image was marked as Exhibit F in Purdy's deposition and discussed on pages 79 to 81. 49, this mimicked crime scene photo or image found on Holder's social media page holds an eerie similarity to the actual crime scene. 50, in the mimicked crime scene image found on Holder's social media page, the bodies of two women appear to be staged, lying on the ground in the woods with branches laid across their bodies. 51, one of the women in the mimicked crime scene image found on Brad Holder's social media has her arms staged or positioned in a similar manner as one of the victim's hands were staged or positioned in this case. 52, at the time that Trooper Purdy observed the mimicked crime scene photo on Brad Holder's social media page, the general public did not have knowledge of the appearance of the crime scene, the positioning of the bodies on the ground in the woods, or that branches and sticks were arranged on the bodies. You get what's being said here? Do you get what's being said? Things only the killers would know. I mean, this is one of the most classic detective strategies in the world. You don't release info because you want that info to be information that only the killers would know. Well, how does Brad Holder pose these girls and put sticks on their bodies in a way that only the killers would know when that information had not been released? 53, in an April 12, 2017 report from Trooper Ryan Winters, it was learned that the state police also came into possession of said mimicked crime scene image through an internet sleuth named Ryan Boucher. Oh, yes, you remember him. Let us not forget about Boucher. 54, Boucher alerted Winters to the disconcerting images on Brad Holder's social media page and then sent said images to Trooper Winters over the internet. 55, on April 12, 2017, Trooper Winters then shared with Jerry Holman his knowledge of the mimicked crime scene images found on Holder's social media pages and other information. 56, because of the similarities between the images that Boucher sent Trooper Winters from Brad Holder's social media and the crime scene, Trooper Winters requested that Brad Holder be re-interviewed. 57, Despite that request, state police ignored Trooper Winters and never re-interviewed Brad Holder. Brad Holder was only interviewed in August 2023 after Jerry Holman was challenged by the defense to reopen the Brad Holder investigation. Yes, Holman seems to be a knee-jerk type of individual. Remember that after the interview of Holder or the deposition, when it was revealed, of Holman, when it was revealed that the defense was sniffing into the direction of Norse pagan symbolism or Odinism, miraculously within a week, the Odinist patches disappeared from the guards' uniforms at Westville. Let us not forget that. 58. To this day, the prosecution has failed to turn over the mimicked crime scene image that Purdy found on Holder's social media in 2017. 59. Fortunately, because internet sleuth Boucher had saved the image that he had turned over to Trooper Winters, the defense team was able to drive to Georgia and retrieve that image. This is called doing actual work. 60. When deposed, Trooper Winters claimed that the state police could not access the images that Boucher found on Holder's social media that Boucher then turned over to the state police, whatever that means. 61. How could the state police lose such an important piece of evidence as an image found on a suspect's social media that mimics the crime scene at a time when the crime scene had not been released and details or photographs were not known? '62. The defense again would proffer that the mimicked crime scene photo was not lost. Logic and common sense dictates that such an important piece of evidence would not be lost by the state police. The defense is filing simultaneously herewith its memorandum in support of its second motion to dismiss based upon newly discovered, destroyed, and or missing exculpatory evidence. 64. As detailed in said memorandum, if the defense can show that the missing evidence is exculpatory in nature, then the defense does not need to show that the missing evidence was intentionally destroyed. 65. If, on the other hand, the defense cannot show that the missing evidence was exculpatory in nature, but can show that the missing evidence is potentially useful evidence, then the motion to dismiss should be granted if the defense can show that law enforcement intentionally or acted in bad faith regarding destroyed or missing evidence. And I think that's clear. The exculpatory nature of missing evidence. 66. Currently, the missing evidence that the prosecution has not turned over to the defense includes the following: video of Brad Holder's first interview from February 17, video of Logan Holder's interview from February 17, data from Brad Holder's phone extraction from February 17, video of Brad Holder's second interview with law enforcement taken at Logansport Police Station sometime in 2017 or 2018. Audio taken from Brad Holder's second interview with law enforcement taken at the Logansport Police Station sometime in 2017 or 2018. Any reports, notes, or documents concerning or referring to Brad Holder's second interview at the Logansport Police Station sometime in 2017 or 2018. The mimicked crime scene photo observed by Trooper Purdy on Brad Holder's social media page and turned over to defense by Ryan Boucher. Images Ryan Boucher sent to Trooper Winters on April 12, 2017. 67. Notice that all missing items are related to third-party suspect Brad Holder. Also, note that the prosecution is asking the defense not to be allowed to even mention the name Brad Holder during trial. Oh, least we forget about that. Remember what Nick doesn't want us to talk about, right? What does Nick not want mentioned? Well, let's pull that up and see for a moment. Detour. Let's take a brief detour here. This is important to refresh our memory on, okay? This is major red flags here. And I may not be able to find it quickly enough for my own satisfaction. Okay, let's see. This is extremely important. I mentioned it several times and I've posted it. But I want to read it again for you because this right here, it's worth the time it will take me. I apologize to you who want to just only get through this document. Fast forward. Okay. Here we go. I got it for you. Look, aren't you happy? Aren't you happy here? Let's see. There you go. The list reads as following. The defense should not be able to mention Odinism, cult or ritualistic killing, Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rob Abrams. Okay, what you call that is the entire Frank's memorandum, 136 pages, as we like to call it. Okay, so we cannot mention anything in the Frank's memo, the 136 pages, that is devastating to this case. Also, no mention of Keegan Kline or Tony Kline. What? No mention of Keegan Kline or Tony Kline. You mean the same person who puts himself and his father there, Keegan Kline, who tells several individuals that not only was he and his father there in Delphi that day, but that that his dad was involved in this with some others, and that all he did was help move the bodies. Yes, you can't mention them. You also cannot mention Ron Logan or any reference to the investigation conducted by Todd Click. Then they subsequently did what? They went after Todd Click's records in order to make it look like he's a corrupt, mentally deranged, untrustworthy law enforcement individual. Well, I think in like is has been common in the social media aspect of this case, what we call that is confession by projection. Okay. Notice, 69. Currently, the list of evidence that the prosecution failed to turn over to the defense until the defense requested the prosecution turn it over upon the prosecution realization that the defense would soon be learning about the existence of said evidence includes Todd Click letter and accompanying 85-page report. The prosecutor held on to this evidence for over 4 fucking months until he knew the defense would learn of its existence. Yes, and now he says, I don't want you to be able to talk about it. Multiple Elvis Fields interview. Don't want you to be able to talk about Elvis Fields. Rod Abrams interviews. Don't want you to be able to talk about Rod Abrams. Multiple Johnny Messer interviews. Don't want you to be able to talk about Johnny Messer. Multiple Taylor Hornady interviews. Ned Smith interview. Liberty German phone dump. Notice all of the items in A through G of paragraph 69 are related to third-party suspects and Odinism, all of which are not to be mentioned by the defense in the trial for Richard Allen. Also note, the prosecution is asking that defense not be allowed to even mention any of these third-party suspects or Odinism. The evidence that the defense does have in its possession showcases that on multiple occasions, third-party suspect Brad Holder has changed his answer concerning a very basic question. How many times has he met Abigail Williams? According to the only police report that memorialized Brad Holder's accidentally destroyed first interview, Holder stated that he had never met Abigail Williams. What? At the time he was first approached by law enforcement, February 17, 2017, and asked that question, how many times did you meet Abby Williams? Common sense would dictate that the answer would be fresh in Brad Holder's mind and easy to detail because A, the proximity and time that Brad Holder's son had dated Abigail Williams, i.e., Logan Holder was dating Abigail Williams at the time of the murders. And B, the enormity of the situation, that two girls had been murdered and one of them dated Brad Holder's son. 75, if Brad Holder was in any way involved in the murders, as the defense believes the evidence to strongly support, then Brad Holder's claim, close in time to the murders, that he never met Abigail Williams is understandable. Denying that he had ever met Abby Williams could cause the police to take their attention off of him. If, at his February 17, 2017 interview, Holder was telling the truth that he never met Abby Williams, then his answer to the police would have when asked the same question 6.5 years later on August 30th, 2023, should easily have been the same. I never met her. Because a father would definitely remember if he had ever met his son's girlfriend who had just been murdered. Conversely, a father would know if he had never met the murdered girlfriend of his son involved in a high-profile case. However, if at his February 17th interview, Holder was not telling the truth as to how many times he met Abby Williams, then it may be difficult for Holder to remember what lie he told law enforcement 6.5 years earlier when he was re-interviewed on August 30th, 2023. Yes, because remember, you tell a lie, it's hard to remember your lies. You tell the truth, well, the truth never changes because it is the truth. So Brad Holder, which is it? You never met her? Or you met her a couple times, including once at Patrick Westfall's, and all of a sudden you magically remember? At his August 30th, 2023 interview, Brad Holder's story changed. Now he claimed that, in fact, he had met Abby Williams one time. That's August 30th, 2023. Either Brad Holder intentionally lied to the police closer in time to when Logan dated Abby, or Brad Holder had simply forgotten his meeting with Abby, but then somehow remembered that meeting 6.5 years later. Then, at his May 2nd, 2024 interview, just 19 days prior to today, he provided yet a third different answer to the question of how many times that he had met Abigail Williams. His answer now is that he actually had met Abigail Williams 2 times. Okay, so 3 different answers. 2017, he says he never met her. 2023, he says he met her 1 time. 2024, now he's met her 2 times, including once at Westfall's. Furthermore, at his May 2nd, 2024, defense, you got to get these dates right. Deposition, Holder remembered that one of those meetings occurred at Patrick Westfall's house. Brad Holder's ever-changing answers to such a simple question provides evidence that the missing items are exculpatory in nature. When combined with the evidence contained on Brad Holder's social media pages, including the images of a rune inked onto Holder's hand that mimicked the way the sticks were formed on Abby's body, and that's confirmed, as well as the other evidence detailed in Frank's 1, the ever-changing stories of Brad Holder on the simple topic of how many times did you meet Abby Williams? Oh, and possibly you've left out the prior knowledge of the crime scene in order to stage bodies and put the hands in the same position and put the sticks on the bodies. Should all provide insight into why the defense believes that the missing evidence contained obviously exculpatory evidence. How could it not? It would be impossible for the defense to show that the missing evidence contains clearly exculpatory evidence. Therefore, the defense is left with providing circumstantial evidence along with logic, reason, and common sense as to why the missing items would contain obvious exculpatory evidence. The defense believes that it has shown that the missing destroyed evidence is exculpatory in nature. The missing destroyed evidence is exculpatory, but even if the court disagrees, the court should find that the missing destroyed evidence would be considered potentially useful and dismiss the charges. Yes, I mean, would you not agree that all of this information would be potentially useful? I mean, that's a pretty low standard, isn't it? Isn't it? Perhaps Mr. Osbrook will comment later on today, if he comes by, as to how low of a standard potentially useful could be in this court. As detailed in the accompanying memorandum, if this court finds that the missing destroyed evidence is not exculpatory, but does find that it is potentially useful, then the court should dismiss charges. If it also finds that law enforcement intentionally caused the potentially useful evidence to be destroyed or acted in bad faith regarding the missing evidence. Franks 1 through 4 provide many details of why this court should believe that law enforcement intentionally caused the potentially useful evidence detailed herein to be destroyed or acted in bad faith. The defense incorporates the contents of Franks 1 through 4 in this motion. And remember, ladies and gentlemen, that all of the Franks 1 through 4 incorporate the 136-page memorandum into themselves. Provided below are a few facts that support the defense contention that law enforcement has acted in bad faith or intentionally lost or destroyed evidence or have failed to turn over said evidence to the defense. Okay, give me one moment, please, and I will be right back. Okay, thank you, ladies and gentlemen. Need a refreshment. Missing portions of vital video from Jerry Holman's October 26, 2022 interrogation of Richard Allen. Remember, this is when he immediately had the fraudulent, questionable PCA written and signed for the arrest of Richard Allen. All right. Now, Jerry Holman interrogated Richard Allen on October 26, 2022, and said interrogation was videotaped. However, the first few minutes of the interrogation are inexplicably missing. Wonder why. The missing portions of that video, according to Jerry Holman, would have shown Holman discussing Allen's Miranda rights and freedom to leave the room. Both important concepts that might support the legality or illegality of Holman's interrogation. No explanation exists as to why the only portion of the videotaped interrogation that is missing is the crucial beginning of the interrogation. The missing video supports the defense contention that Holman knew he had screwed up and therefore edited out the first few minutes of the interrogation to avoid the statement being suppressed. The missing video from Holman's October 26 interrogation of Richard Allen is evidence of the intentionality of law enforcement involving this concealment or destruction of evidence and/or evidence of bad faith. Yes, did he not read Richard Allen his Miranda rights? Did he not offer him the freedom to discuss or not discuss or leave or not leave? What happened there, Holman? B. Jerry Holman lied in his August 10, 2023 deposition that Brad Holder was never a suspect. Well, I think that's obvious. In his August 10th, 2023 deposition, when asked if Brad Holder was ever a suspect, Holman said the following: "Not really, no. However, it is clear from reviewing emails between Doug Carter and the FBI that Brad Holder was a suspect early on in the case. As stated before, Holder was thought to be a suspect, and his name was known as a suspect even at the highest level of the state police. That's right, by Superintendent Doug Carter and Indianapolis FBI agent Jay Abbott. The fact that Holman misled the defense, claiming that Holder was not really a suspect, or no, is evidence of the intentionality of law enforcement involving both the concealment of evidence and the evidence of bad faith." The prosecution failed to turn over the Todd Click exculpatory evidence for 4 months and then only turned it over after it was obvious that the defense would be learning of the existence of the Click letter. Yes, remember that entire thing. I'm losing track. I'm losing my train of thought. Remember that entire fiasco, right? About the whole Click letter. It's just like the Odin patches disappearing when Dennis Hall came up. As detailed in Frank's 1 and the numerous other pleadings, the prosecution chose to not turn over exculpatory evidence from May 1st, 2023 until September 8th. Okay? Of a letter of Todd Click in the 85 pages detailing his investigation. Yes, that's more than 4 months. Contained in the Click letter was evidence that 3 law enforcement officers who investigated the case believed that third-party suspects, Brad Holder, Patrick Westfall, and Elvis Fields, among others, were involved in the murders, and Click's belief that the evidence supporting their involvement in the murders was much more compelling than the evidence against Richard Allen. And I think that's pretty much consensus reality with all of us today. As stated in a previous pleading, it is hard to believe that a stronger example of exculpatory evidence could exist than documentation that 3 law enforcement officers are essentially believed that the wrong man may have been arrested. The fact that the prosecution refused to not immediately turn over the exculpatory This is poorly stated. This is somewhat of a error in syntax here. It should read that the fact that the prosecution refused to immediately turn over the exculpatory Click letter for over 4 months is evidence of the intentionality of law enforcement involving the concealment of evidence and/or evidence of bad faith. Yes, I mean, I think there's so many points involving the concealment of evidence and many instances of the evidence of bad faith. The prosecution failed to turn over exculpatory evidence contained in several videotaped statements until after the prosecution knew that the defense would soon learn of its existence. Yes, that's true. That is true. As detailed earlier in this motion and in Frank's 1, the prosecutor failed to turn over several videotaped interviews that provide exculpatory evidence concerning third-party suspects until after it was clear the defense would soon be learning of the existence of those videotaped interviews. The prosecutor turned over these videotaped interviews nearly 9 months later than required under rule and statute, which is 30 days. Those videotaped interviews provided exculpatory evidence in terms of blown alibis of third-party suspects, as well as connectivity between third-party suspects and also provable lies told by third-party suspects concerning their knowledge of other third-party suspects. The fact that the prosecution failed to turn over exculpatory evidence that supports the involvement of third-party suspects in committing the murders until after the defense would soon learn of their existence is evidence of the intentionality of law enforcement involving both the concealment of evidence and I would say even more so, evidence of bad faith. The prosecution and law enforcement attempted to conceal the identity of a Purdue professor whose testimony contradicted the sworn statement of Jerry Holman. Oh yes, you will remember this. And you who are new to this case may not know about this, but this is another extremely concerning point regarding Jeffrey Turco. This matter has been detailed in Franks 1, 2, and 3, and in other various pleadings that have been previously filed. At his August 10, 2023 deposition, Jerry Holman stated under oath that part of the reason that law enforcement ruled out the persons practicing Odinism or some type of cult had committed the murders was because a Purdue professor had ruled out such a possibility. However, after reviewing the Purdue professor's report prepared on or about March 1st, 2017, think of how close this is to the time of the murders, ladies and gentlemen. 2 weeks. As well as listening to the Purdue professor's September 19th, 2023 interview, it was determined that the Purdue professor, Jeffrey Turco, never made such a statement as Jerry Holman had stated in his deposition. Yes, in other words, Jerry Holman was doing what Jerry Holman do, which is shift. Let's shift that over here. Furthermore, at his deposition, the Purdue professor Jeffrey Turco specifically denied that he had ever made the very statements that Holman attributed to Turco. Wow, yes, we remember that. Additionally, the prosecution told the defense in a September 6, 2023 email that the identity of the Purdue professor was still unknown and may not ever be able to be found. Oh, you remember that. This was untrue as Jerry Holman had already learned of Jeffrey Turco's name weeks earlier, if he did not know it already. Additionally, the defense learned that the actual Purdue report from March 1st, 2017, which contradicted Holman's deposition testimony, was in the possession of law enforcement since that time, but was purportedly rediscovered by law enforcement in August of 2023. The prosecution finally produced said report to the defense on October 4th, 2023, and only upon the request of the defense. Jerry Holman's August 10, 2023 deposition. Testimony was false concerning the findings of the Purdue professor, and therefore his testimony is evidence of law enforcement's intentionality in attempting to conceal evidence and or evidence of bad faith. Yes, not only was it false, it was misrepresentation of the entire consensus of not only Jeffrey Turco, but the Harvard professor who he consulted with. The attempt of law enforcement and the prosecutor to conceal the identity of the Purdue professor is further evidence of the intentionality in attempting to conceal evidence and or evidence of bad faith. Yes, because they did not want the defense to find Mr. Turco and discover that they were misrepresenting Mr. Turco's and the Harvard professor's opinions that yes, indeed, the stick formations found on the girls were likely someone's attempt to replicate Nordic runic script or someone's idea of what Nordic runic script might look like. The prosecution failed to turn over one of the key pieces of evidence for nearly 9 months, and then only after the defense kept requesting the prosecution for the same. All right, here we go. A key piece of evidence that in this case is the phone data extracted from victim Liberty German's phone. The prosecution and law enforcement had possessed that evidence for 5 years prior to Richard Allen's arrest, and therefore should have been able to provide that evidence immediately to the defense. However, the defense did not receive that evidence until September 8, 2023, almost 9 months later than required under criminal rule, which is 30 days. After the defense had a chance to review said data from the phone, it was determined that exculpatory evidence existed in the phone that did not support law enforcement's timeline and supports that third-party suspects were involved in the murders. Let's talk about that, because what we're talking about now is the AT&T pinging of Liberty German's cell phone. Yes, that's what we're talking about. What do we mean by that? The fact that Liberty German's phone stopped pinging at 5:44 p.m. well after Richard Allen had allegedly left the scene. Not only that, Liberty German's cell phone magically somehow, miraculously turned back on and started pinging again at 4:30 in the morning on February 14th, just hours before her body was discovered. Where was Richard Allen at this time? The prosecution and law enforcement had possessed that evidence for 5 years. After the defense had a chance to review said data from the phone, it was determined that exculpatory evidence existed. The failure of law enforcement to turn over Liberty German's phone for nearly 9 months, thereby concealing exculpatory evidence the defense could have been exploring from the beginning of their representation, is further evidence of intentionality in attempting to conceal evidence and/or evidence of bad faith. Yes, you stole 9 months from the defense of Richard Allen in regards to exploring the contents of Liberty German's cell phone. Law enforcement concealed the Blocher report until April 26, 2024. On April 26, 2024, the state of Indiana turned over a report from Steve Mullen concerning the findings of Sergeant Mitch Blocher of the Indiana State Police. Contained in the body of that report was exculpatory information concerning the ping information that supports that on February 13th, 2017, the victims were not located at the same scene as they were found on February 14th, 2017. Oh, this is what we call the timeline completely fucking falling apart, as if it already hasn't been falling apart for a few years now. The failure of law enforcement in turning over this report for well over 1 year beyond when the prosecution was required to turn it over, and only after the defense sent a certified letter and filed a motion to compel and for sanctions demanding that the prosecutor turn over certain evidence, is further evidence of intentionality in attempting to conceal evidence under evidence of bad faith. Tobe Lesenby contradicted the sworn testimony of both Jerry Holman and Tony Liggett concerning the number of people involved in the murders. Ooh, this gets rich. The matter is detailed in Frank's 1. Both Liggett and Holman testified under oath that only one person and one person only, and that is your Mr. Richard Allen, was involved in the murder of the victims. The proclamation under oath by Ligon and Holman would negate the defense's contention that evidence supports that multiple people involved in Odinism were involved in the murders. However, when Tobe Leazenby was deposed, he stated under oath that Tony Liggett actually believed that multiple people were involved in the murders. And that's what the prof believes, and 90% of you out there. Oh, yeah, we know what we believe. This conflicting sworn testimony of law enforcement is further evidence of intentionality on the part of law enforcement to conceal their actual beliefs concerning the number of people involved in the murder of the victims in order to direct the defense away from theories that Odinist or others were involved in the murders, and additionally is evidence of bad faith. Yes, and what about prosecutor Nick McClellan himself stating that he had reason to believe that other actors were involved? No recordings of Richard Allen's interview with Dan Doolin exist. That's not suspect at all, is it? In 2017, Dan Doolin has stated that he knew that he had audio recorded interviews when conducting interviews of tips or leads. Doolin claims that he now believes that he never audio recorded his interview of Richard Allen. Quote, I think I must not have audio recorded it because all the other ones that I had are in a file on my computer, and I listened to each of them just in case they were mislabeled. Every audio recording I have, and none of them was Mr. Allen. This interview is crucial as to what Doolin claims Allen told him. This helps establish the timeline used to secure a search warrant to arrest Allen. The defense believes that Richard Allen was tape recorded and that the missing tape supports intentionality on the part of law enforcement and evidence of bad faith. Who knows? Missing mimicked crime scene image. This was detailed earlier in this motion and in Frank's one. The fact that this incredibly exculpatory piece of evidence cannot be accessed and therefore is still missing, causing them to travel to Georgia to obtain said image, is evidence of intentionality on the part of law enforcement to conceal exculpatory evidence and or evidence of bad faith. Yes, I would agree with that. I would say more than anything, it's evidence of bad faith. Brad Holder is a key third-party suspect. Yet, Jerry Holman denied that fact, and then law enforcement failed to turn over multiple pieces of evidence that support Holder's involvement, along with other third-party suspect identified in Frank's one. Furthermore, law enforcement have claimed that Brad Holder's initial interview was taped over. Oh, conveniently. Furthermore, law enforcement claim apparently that they never extracted data from Brad Holder's phone when they extracted data from at least 101 other phones from people who weren't even suspects, like Brad Holder was. Yes. Furthermore, law enforcement claim apparently that they never extracted data from Brad Holder's phone when they extracted data from Logan Holder's phone, which was turned over to the police at the exact same time that Brad Holder turned over his phone. Furthermore, law enforcement has turned over zero evidence of Brad Holder's second interview conducted at the Logansport police station, and the defense has only learned of said interview through a deposition of Brad Holder conducted on May 2nd, 2024. Furthermore, law enforcement claim that they cannot access the mimicked crime scene photo that was on Brad Holder's social media page. All of the issues of missing evidence surround one person, Brad Holder, and Odinism, which the prosecution is also attempting to block the defense from even mentioning at trial. Yes, let's read that again. What's the list? You cannot mention Odinism, cult or ritualistic killing, Brad Holder, Patrick Westphal, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Klein, Jerry Klein, or Ron Logan, or the Todd Click information. That's right. Richard Allen cannot have a fair trial when exculpatory evidence that would support the involvement of third-party suspects is missing. Only so many coincidences can explain away why so much evidence concerning Brad Holder and Odinism is still missing, and why the prosecution failed to turn over much of the evidence that the defense does in fact possess concerning third-party suspects for 9 months or more, and only after the prosecution knew that the defense would soon be learning of the existence of that third-party suspect evidence. Yes. So you stole 9 months or more from the defense being able to work all of this information that you withheld. What else are you withholding at this very moment in time? The bad faith of law enforcement and prosecution has been proven through these numerous examples of missing evidence and evidence that the prosecution failed to turn over to the defense in a timely manner. Because the missing evidence is exculpatory in nature, the charges against Richard Allen should be dismissed. Even if the court finds that the missing evidence is not exculpatory, it is clearly potentially useful evidence. And that is something that the prof 100% agrees with. Who can deny paragraph 101 here? Who could deny it? Let me read it slowly and clearly again, because this right here, it's amazing. Oddly enough, 101 paragraphs, just like we have 101 phone dumps. Even if the court finds that the missing evidence is not exculpatory, it is clearly potentially useful evidence. And the numerous examples of bad faith contained in this motion require that charges against Richard Allen be dismissed. Now, do you think Judge Gull will dismiss this? No way in hell. No fucking way in hell that this biased, unhinged judge is going to dismiss this. But guess what this does? Oh yeah, it puts it in the record. Okay? It puts it in the record for appeals. That's what this is. I know you thought it was over, but it ain't. Memorandum of law in support of defendant's second motion to dismiss based upon newly discovered, destroyed, and or missing exculpatory or potentially useful evidence. Again, to be put into the record, at issue is the purposeful. Need some water then. How's everyone in the chat? Pardon me for this laborious reading tonight. Pardon me for that, but it is what it is. It's laborious. At issue is the purposeful or negligent failure to preserve and or the destruction of material and exculpatory evidence critical to the defense of Mr. Allen. It also involves the attempted concealment of the identity of a key witness, Mr. Jeffrey Turco, and other exculpatory evidence, such as the Todd Click letter and evidence referred to by Click in his letter. This would include new examples of missing evidence detailed in the motion filed simultaneously herewith. Yes, and we just read through all of that. Oh my gosh. Let's try to get through this. I'm not going to read the specific code for each one, okay? I'm just going to skip over having to read out numbers to you. But understand the basics of the points that are being made here. Indiana Code states that this court may, upon motion of the defendant, dismiss an information upon certain grounds. In this case, the defendant requests the court to dismiss this information pursuant to a code which states that a motion to dismiss an information may be granted for, quote, any other ground that is basis for a dismissal as matter of law. Such grounds would include a violation of a defendant's constitutional rights to due process. Additionally, trial courts have inherent authority to dismiss criminal charges where the prosecution of such charges would violate a defendant's constitutional rights. Additionally, trial courts, such grounds would include a violation of a defendant's constitutional right to due process. A motion to dismiss based upon a ground specified in Indiana Code may be made or renewed at any time before or during trial. Therefore, this matter is properly and timely raised. Okay, so you understand that point, right? It may be made or renewed at any time before or during trial. So yes, this is properly and timely raised. The Indiana Supreme Court has held that, quote, a serious breach of duty occurs when the prosecution willfully or intentionally, when unjustified by public policy, obstructs the access of the defense to material evidence in its possession. It is likewise a serious breach when, through lack of vigilance, the negligent destruction or withholding of material evidence by law enforcement officers or the prosecutor occurs. In such instances, grounds for reversal may exist. The Indiana Supreme Court has also held that the negligent or intentional destruction of evidence by the police can provide grounds for reversal or dismissal on due process and due course of law grounds. Are you getting a flavor of this memorandum? Prior to any request for discovery by the defendant, the negligent destruction or withholding of material evidence by the police or the prosecution may present grounds for reversal. The Indiana Supreme Court has further held that, quote, when the prosecution determines evidence to be non-material and further decides not to advise defense counsel of such evidence prior to its destruction, a heavy burden rests upon the prosecution to demonstrate that the destruction of such evidence did not prejudice the defendant, close quotation. Are you picking up this flavor of this document yet? The appropriate test to apply when deciding whether a defendant's due process rights have been violated by the state's failure to preserve evidence depends on whether the evidence in question was, quote, potentially useful evidence, or, quote, materially exculpatory evidence. The burden is on the state to demonstrate that this evidence was not material and its destruction did not prejudice the defendant. The burden is on the state, not the defense. Potentially useful evidence is defined as, quote, okay, maybe this is, remember I asked for Mr. Osbrook to chime in on this? Well, maybe this is going to clear it up for both he and I. Evidentiary material of which no more can be said than it could have been subjected to test, the results of which might have exonerated the defendant. I mean, that's an extremely low bar right there. That's extremely easy, isn't it? I mean, listen to that definition. If all Richard Allen's defense has to prove is that this evidence, and I'm talking all 101 paragraphs that we just read, if all they were at a minimum potentially useful, this case should be dismissed. Listen to this. Potentially useful evidence is defined as follows. Evidentiary material of which no more can be said than that it could have been subjected to test, the results of which might have exonerated the defendant. I mean, for me, that sounds like it's a very low standard, I believe. Could have been subjected to tests, the results of which might have exonerated. Whew. Oh my gosh. It's so mind blowing. We still can't even get a Frank's hearing? If the state's failure, I'm sorry, the state's failure to preserve potentially useful evidence constitutes a due process violation when the defendant can show bad faith. The Seventh Circuit has held that bad faith may be inferred when a party, quote, disposes of evidence in violation of its own policies. Violation of a record retention regulation creates a presumption that the missing record contained evidence adverse to the violator. The bad faith presumption arises when the failure to retain records or other evidence actually violates the terms of the applicable policy. However, the Indiana Court of Appeals has noted that in some instances, the destruction or failure to preserve evidence may be so prejudicial to the defendant as to warrant reversal, even in the absence of bad faith by the officers. In other words, bad faith doesn't have to be proven. I mean, doesn't that seem like what the Court of Appeals has noted? That you don't even have to prove bad faith. Materially exculpatory evidence, on the other hand, is defined as evidence that possesses, quote, an exculpatory value that was apparent before the evidence was destroyed, and is of such a nature that the defendant would be unable to obtain comparable evidence by any other reasonably available means. The state's good or bad faith in failing to preserve materially exculpatory evidence is irrelevant. In other words, once again, bad faith is not even relevant here. The Indiana Supreme Court has held that the defendant must establish materiality as a condition precedent to claiming a denial of due process where evidence is negligently lost or withheld by the government, except where the materiality is self-evident or a showing of materiality is prevented by the destruction of the evidence. Right, so the showing of the materiality is prevented by the destruction of the evidence at question or in question. I mean, this memorandum here is making it look really easy, in my opinion. In this matter, given the nature of the evidence that law enforcement either failed to preserve or actually disposed or actually destroyed, the materiality was and is self-evident. Further, as in Lee, the failure to preserve or destruction prevents the defense from establishing the exculpatory nature of the evidence and its materiality. That's what I was just saying. As such, Allen is not required to demonstrate the materiality of the evidence. That's what I was implying. To be sure, the unavailable evidence had exculpatory value, which was apparent at the time it should have been preserved and prior to its destruction. Additionally, Allen is unable to obtain comparable evidence by any other reasonably available means. Quote, spoliation of evidence is the intentional destruction, mutilation, alteration, or concealment of evidence. If spoliation by a party to a lawsuit is provided, rules of evidence permit the jury to infer that the missing evidence was unfavorable to that party. In this instance, it would mean the state. Quote, even if the court requires a showing of bad faith, it is apparent. As I just mentioned, it's not even required. These are very easy to meet here. Bad faith is defined as being not simply bad judgment or negligence, but rather implies the conscious doing of wrong because of dishonest or purpose or moral obliquity. And remember, Holman denying that he knew Turco's name. Remember, Holman misrepresenting Turco's statements and opinion and that of the Harvard law professor. Remember, obliquity is defined as deviation from moral rectitude rectitude or sound thinking. Well, I think we have a lot of that in this Delphi investigation. The U.S. Supreme Court has recognized that the police have a constitutional duty to preserve such evidence. In Trombetta, the Supreme Court observed that whatever duty the Constitution imposes on the states to preserve evidence, that duty must be limited to evidence that might be expected to play a significant role in the suspect's defense. The court recognized that same duty in Arizona versus Youngblood, confirming that the Constitution imposes at least a limited obligation on the police, quote, to preserve evidence that could form the basis for exonerating the defendant, close quotation. It is beyond debatable that the evidence at issue here would play a significant role in Mr. Allen's defense and would form a basis for exonerating him. Additionally, here we go, the suppression, and this is quotation, the suppression, this is from Brady. This is from Brady v. Maryland. Quote, the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith of the prosecution. Quote, to prevail on a Brady claim, a defendant must, one, establish that the prosecution suppressed evidence. Well, that's established. Two, that the evidence was favorable to the defense. That's established in my mind. And three, that the evidence was material to an issue at trial. Established in my mind. So I mean, to me, it's like, do we have a Brady violation here? Indiana Constitution. Now we're turning a whole new page. It's a whole other leaf here. It is clear that the federal Constitution is not the sole guarantor of the rights to due process and other rights. Chief Justice Shepard made this abundantly clear in his Law Review article, Second Win for the Indiana Bill of Rights, when he stated in conclusion that, quote, civil liberties protected only by a U.S. Supreme Court are only as secure as the Warren Court or the Rehnquist Court wishes to make them. The protection of Americans against tyranny requires that the state Supreme Courts and state constitutions be strong centers of authority on the rights of the people. I am determined that the Indiana Constitution and the Indiana Supreme Court be strong protectors of those rights. The Chief Justice also stated that, quote, Indiana was an early and noteworthy participant in using its Bill of Rights to defend personal liberty, quote, close quotation. And after citing numerous early decisions, noted that, quote, these were but a few in a fine line of cases in which the Indiana Supreme Court held that the Indiana Bill of Rights afforded Hoosiers rights which the federal Constitution did not. Close quotation. And let me comment here. That is the case with all states. The federal Constitution provides your minimum constitutional rights. Every state adds to the protections of the federal U.S. Constitution. It's not the other way around. Chief Justice Shepard also made a note of the fact that many provisions of the Indiana Bill of Rights have no counterpoint in the U.S. or counterpart in the U.S. Constitution, and observed that Article 1, Section 12 was one of those provisions. This provision relating to due process is at issue in this instance. The Due Process Clause of the U.S. Constitution is found in Section 1 of the 14th Amendment to the Constitution. That section states in relevant part that, quote, no state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law. The right to due process conferred under the Constitution of the State of Indiana is found in Article 1, Section 12, and contains significant language not found in the Constitution of the United States. The provision states, quote, all courts shall be open, and every person, for injury done to him in his person, property, or reputation, shall have remedy by due course of law. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. While the defense is unaware of any Indiana case law specifically interpreting the emphasized portion of this constitutional provision, the provision itself was traced back to the Magna Charta in the State ex rel Board of County Commissioners versus Larimore. The Larimore court also acknowledged that although the provision was derived from the Magna Carta, it may be a broader guarantee of free, unpurchased, and impartial justice. Three more contemporary decisions dealing with the issue of destruction of evidence are of particular import. First, it is clear from the Chief Justice Shepard's concurrence in House v. State that the issue of whether a lack of good faith on the part of a state was required for a defendant to obtain a remedy for destruction of potentially exculpatory evidence under the Indiana Constitution had not been adversely decided adversely to the defendant, even after Youngblood. The House decision actually dealt with the discovery of potentially exculpatory evidence, the need for materiality of that evidence. Uh, Both Chief Justice Shepard and Justice DeBruler, however, discussed the related issue of destruction or loss of such evidence. In his concurrence and dissonant, Judge DeBruler stated that, quote, while I agree with the result reached by the majority opinion on this discovery issue, I point out that when the accused shows that the material evidence was in the hands of the prosecution and lost, the question of whether the accused must then go ahead and show prejudice is open in Indiana. In my judgment, when the item is not available for scrutiny by trial court, but is known to have been material, the risk of loss should be borne by the prosecution. Remember, burden to the prosecution and not the defendant. The police and the prosecutors are, after all, highly trained specialists in the gathering and retention of evidence and should be expected to carefully retain all material evidence in usable form. Close quotation. Chief Justice Shepard in his concurrence stated that I agree with Justice DeBruler that this case does not decide what standard Indiana should use for cases in which the prosecution has disposed of arguably material evidence which might exculpate a defendant. The instant case certainly appears to be the type envisioned by these comments. Two Indiana decisions have been found in which the issue of due process and the destruction of evidence was raised under both federal and Indiana constitutions. Hale v. State, Douglas v. State. Although both of these decisions were determined adversely to the defendants based on the facts of the cases, both also stated that the negligent or intentional destruction of material evidence by the police or prosecution may present grounds for reversal. Well, I think that's clear by now. In each case, the defense alleged a violation of due process under both federal and state constitution. While both decisions were rendered prior to the U.S. State Supreme Court's decision in Youngblood, the decision in House rendered after Youngblood decision makes it clear that the principle announced in Hale and Douglas may still be valid under the Indiana Constitution. Additionally, Lee Supra was decided after Youngblood. If the language in Article 1, Section 12 of the Indiana Constitution, quote, justice shall be administered freely and without purchase, completely and without denial, speedily and without delay, close quotation, is to have any meaning at all, certainly seems to support a more stringent enforcement of due process rights than required under the federal Constitution. Remember, that's what I was stating. More protection than the U.S. Constitution, not less. Given the facts of the instant case, the penalty involved, and the long history of concern about preservation of evidence in Indiana case law, as well as evidence of attempts of law enforcement and the state of Indiana attempting to conceal other material and exculpatory evidence, Mr. Allen should not be deprived of a remedy for the egregious loss of evidence occasioned by the actions of law enforcement and or the prosecution in his case, especially in light of the ease with which the evidence could have been preserved. Conclusion: the only remedy that serves the interests of justice and guarantees Mr. Allen's constitutional rights is dismissal. Okay, so that's your memorandum. Now, I'd like to bring your attention to a document before we close. Just one moment, please. Okay. This is the Justice Manual from the U.S. Department of Justice. Title 9, Organized Crime and Racketeering. Okay. So we are going to dive into this. This can be found online if you choose to explore it. Okay, we're going to flip the page here, and we're going to read some excerpts from this. All right, so I want you to draw your attention to the highlighted portion. On October 15th, 1970, the Organized Crime Act of 1970 became law. Title 9 of the Act is the Racketeer, Influenced, and Corrupt Organizations Statute, commonly referred to as the RICO statute. The purpose of the RICO statute is, quote, the elimination of the infiltration of organized crime and racketeering into legitimate organizations operating in interstate commerce. Close quotation. However, the statute is sufficiently broad to encompass illegal activities relating to, quote, any enterprise affecting interstate or foreign commerce. Section 1961-10 of Title 18 provides that the Attorney General may designate any department or agency to conduct investigations authorized by the RICO statute, and such department or agency may use the investigative provisions of the statute or investigative power of such department or agency otherwise conferred by law. Absent a specific designation by the Attorney General, jurisdiction to conduct investigations for violations of U.S. 18 U.S.C. 1962 lies with the agency having jurisdiction over the violations constituting the pattern of racketeering activity listed in 18 U.S.C. 1961. Okay. Now we're going to forward to section 19-110-200 here. RICO Guidelines Preface. The decision to institute a federal criminal prosecution involves balancing society's interest in effective law enforcement against the consequences for the accused. Utilization of the RICO statute, more so than most other federal criminal sanctions, requires particularly careful and reasoned application. Because, among other things, RICO incorporates certain state crimes. One purpose of these guidelines is to re-emphasize the principle that the primary responsibility for enforcing state laws rests with the state concerned. Despite the broad statutory language of RICO and the legislative intent of that statute, shall be liberally construed to effectuate its remedial purpose. Okay, do you understand the meaning there? So the statute shall be liberally construed to effectuate its remedial purpose. It is the policy of the criminal division that RICO be selectively and uniformly used. It is the purpose of these guidelines to make it clear that not every proposed RICO charge that meets the technical requirements of a RICO violation will be approved. Furthermore, the criminal division will not approve imaginative prosecutions under RICO which are far afield from the congressional purpose of the RICO statute. A RICO count which merely duplicates the elements of proof of traditional Hobbs Act, travel app, mail fraud, wire fraud, gambling, or controlled substances cases will not be approved unless it serves some special RICO purpose. Only in exceptional circumstances will approval be granted when RICO is sought merely to serve some evidentiary purpose. Okay. These guidelines provide only internal Department of Justice guidance. These are not intended to, do not, and may not be relied upon to create any rights, substantive or procedural, enforceable at any law by any party in any civil matter or criminal, nor are any limitations hereby placed on otherwise lawful legislative prerogatives of the Department of Justice. Okay. We're going to skip ahead. Here we go. Uh-oh. Did I skip past it? I think I did. Oh, come on. Oh, what happened? Oh, well, what a bummer here. What a bummer. It's blocked out. The exact portion I wanted to read here is blocked out. Listen to this, okay? Please listen to this. For some reason, I seem to have deleted it. What I attempted to do was to highlight it, and it looks like here that I've deleted it. But here's section 9, 110, 330, charging RICO counts. A RICO charge where the predicate acts consist only of state offenses will not be approved except in the following circumstances. A, local law enforcement officials are unlikely to investigate and prosecute otherwise meritorious cases in which a federal government has significant interest. B, significant organized crime involvement exists. Or C, the prosecution of significant political or government individuals may pose special problems for local prosecutors. Please let me read that to you again. Sorry that apparently I've deleted it when I meant to highlight it. A RICO charge where the predicate acts consist only of state offenses will not be approved except in the following circumstances. A, local law enforcement officials are unlikely to investigate and prosecute otherwise meritorious cases in which the federal government has significant interest. Significant organized crime involvement exists, or the prosecution of significant political or government individuals may pose special problems for the local prosecutors. Okay. So I apologize for not having that for you, but I made a mistake. Mistakes happen. Okay, and let's look at our final section that I've highlighted here. Section 9.110.8.12, specific guidelines for section 1959 prosecutions. Okay, pay attention to paragraph A here. In deciding whether to approve a prosecution under section 1959, the Violent Crime and Racketeering section will analyze the prosecution memorandum and proposed indictment to determine whether there is a legitimate reason the offense cannot or should not be prosecuted by state or local authorities. For example, federal prosecution may be appropriate, please listen here, where local authorities do not have the resources to prosecute, where local authorities are reasonably believed to be corrupt, where local authorities have requested federal participation, or where the offense is closely related to a federal investigation or prosecution. A prosecution will not be authorized over the objection of local authorities in the absence of a compelling reason. Accordingly, every prosecution memorandum must state the views of local authorities with respect to the proposed prosecution, or the reasons for not soliciting them. In addition, the specific factors set forth in the following sections would be considered with respect to all proposed prosecutions. Okay, so why have I highlighted this particular paragraph? Because this is a paragraph which is disclosing to you, the listener, what guidelines the Department of Justice will consider in deciding whether or not to approve a prosecution under RICO. And in particular, where these examples are given, I think we hit upon a very pertinent point, which this Delphi case seems to be giving us a glimpse into. And that is that federal prosecutors or prosecution may be appropriate where local authorities do not have the resources to prosecute. Well, that's not true in this case. Where local authorities are reasonably believed to be corrupt. Whoa. And I think most importantly, where the offense is closely related to a federal investigation or prosecution. So let us go back to this section 9.110.330, charging RICO counts. Remember, a RICO charge where the predicate act consists only of state offenses will not be approved except in the following circumstances. Local law enforcement officials are unlikely to investigate and prosecute otherwise meritorious cases in which the federal government has significant interest. Significant organized crime involvement exists, and or the prosecution of significant political and or governmental individuals may pose special problems for local prosecutors. So if we consider the guidelines and the exceptions in these following circumstances that I just read, in combination with this predicate that I read to you in the preface here, I think it's personally, I feel that it is very likely that this bar is met by what we are seeing evidenced in Indiana. It's my opinion that it is likely that there is a RICO investigation, prosecution underway. If there is not, it's my opinion that there probably should be. And I think it's pretty much the consensus of most people who are following this case in particular and others around Indiana. I mean, don't forget about the Jamie Knoll case, which is currently ongoing. So my opinion is that's where we are. And I think that, like I mentioned in this title, the defense has blasted this state's case. I don't think that it's just poked holes in the case. I think it has completely blown it out of the water. I mean, if you think back to the absolute nuclear bomb that the defense dropped on the prosecution in September, I believe it was September 18th of 2023, with the first Franks motion and the 136-page memorandum, uh, the very thing that caused the YouTube streets to freak out, and not only to create an entire leak scenario, but also to try to completely destroy and take down not only my channel, but the Miao Dezong and several other channels, including Little Joe Lewis and Michael Phillips. Okay, they've tried to take us all down, contingent with the release of the Franks Memorandum. It's been constant warfare since then. Uh, and I think there's a reason. I think there's a reason that you've seen such extreme uh, chaos in the social media commentary on this case. People often ask, why is it such a circus? Why is this case such a circus? Well, ask yourself, why is this case such a circus? Why does this case appear to involve racist, skinhead, white supremacist organizations or individuals tied to those organizations, which are classified as hate groups, which are also party to federal investigation? This case in September of 2023 experienced a nuclear disaster. What you have seen since September 18th, 2023 has been the fallout from that nuclear disaster. and and what you see here on these YouTube streets are individuals trying to survive this nuclear disaster on all sides. And and I think that with this motion here and the memorandum accompanying, the defense has not only dealt somewhat of a final blow to this case, but has set up on record uh, a very good, a very good showing for potential original action. Uh, I think if this ever, if there ever is a conviction on this case, I believe it's over. I mean, I like I started the show with, I think this case is over. Okay, I think it's over. And I have also stated to you that I have no opinion that is 100% on either side, whether Richard Allen is innocent or guilty. Uh, I think regardless of his innocence or guilt, I think this case is completely over. I think that the bad faith and malfeasance on the side of law enforcement is pretty evident. I think that it's being blamed on negligence. I think that the ne'er-do-wells would have you believe that this is solely because it's Andy Griffith over in Delphi, and that Barney Fife was running the unified command. But we are all smarter than that. We can clearly see that that's not the case. Okay, this is not negligence. These are not dumbass country boys making dumbass country boy mistakes that have never dealt with a murder in their entire lives. When you're telling me that not only was the Delphi police involved, but the Carroll County Sheriff was involved, and the Indiana State Police was involved, and the Federal Bureau of Investigation was involved, you cannot tell me that this is merely some good old boys making mistakes because they've never dealt with a murder in their entire lives. Okay, this is not Andy and Barney. Okay, so don't buy it. Don't buy it when they say that. When they say that, clap back with the fact that no. How is it so when FBI was boots on the ground? This is straight up malfeasance. corruption, cover up, and you have to ask yourself, what are they hiding? And why are they in all-out desperation mode since September 18th, 2023? Anyhow, I want to say God bless you to the victims, Abigail Williams and Liberty German. Rest in peace. I hope that your memory lives on forever, and and that you are served justice in the end, no matter what, no matter who is responsible, no matter who goes down, no matter what transpires in the bringing of justice to you girls. I hope that you girls find justice. You deserve justice. It's been 7 years. It's long enough. I think the greatest honor to your memory would be justice being found for you girls, so that your memory can carry forward in the way that you lived your lives and the beautiful energy that you brought to the world, and not this insane circus that has become the social media commentary and the case against Richard Allen for your murders. And so that's my prayer for you, young ladies, and my prayer for you people out there who follow this case and who feel similarly in the search for justice for these girls. I hope that you find peace, and I hope that that you're able to walk upright in this and carry forward from this, because this circus has had a tangible effect on the lives of all who follow this case, and it's really a damn shame. This case has caused so much evil and hurt and pain to so many, and we would not wish that on anyone. And so I want to thank everyone in here, and I want to thank Little Joe Lewis, and I want to thank Michael Phillips, and I want to thank Fort Pitts, and I want to thank all of you in the chat, and all of you in this past year who's participated in this channel, for all of your hard work, your stimulating conversation and debate, and I really want to wish you the best and hope that you find the peace and happiness that you all deserve as being part of an effort to bring about true justice for these girls, because I know that that is my cause, and I know that it's your cause. And wow, this circus is just it's the most insane thing I've ever seen in my life, and I know no one wants any part of it. And let's hope that it comes to an end soon, and that the truth is brought to light, which would be true justice for the victims of the Delphi murders, Abigail Williams and Liberty German. And with that, I bid you guys good night. Thank you so much. Please support the channel. Hit me some likes. Send me some donations. Remember, I'm trying to raise funds for the legal action over on the GoFundMe. I have all my support pathways, and just hit the likes. And please go watch Silky's channel. She did a nice live stream with us, and as she always does, she's such a sweetheart. And anyway, we thank you all for being here, and God bless you and good night. And I love you guys, okay? So we'll see you next time. And God bless Abby and Libby. Thank you.